Parliament this week was discussing criticism against it around the Immigration Act. Last month, the Constitutional Court heavily criticised the National Assembly, the Home Affairs Minister and the Director General, all for not amending the Immigration Act for the past 6 years. So way back in 2017, the Constitutional Court declared that the Immigration Act, or certain sections of it, were unconstitutional, and then gave Parliament 2 years to amend the law. Let's discuss with immigration law expert Ashraf Essop. Mr. Essop, thank you for joining us. Take us back to 2017, and what do the courts say is wrong with the Immigration Act?
Hi, good evening, and thanks for the invitation. So in 2017, certain laws affected detainees. Now, if you look at the Criminal Procedures Act, any accused is entitled to be present to the court within 48 hours of his arrest. So if you presented the accused after 48 hours, that was procedurally incorrect, and he could ask for a discharge. In the case of people that were detained for immigration purposes, that extension of Section 48 was not available to them. In fact, they could be held for 30, 60, 90 days in certain cases. And in order to present themselves before the court to confirm their detention, they had to make application. So you can imagine that this situation was not going to be unchallenged. And the Lawyers for Human Rights then approached the courts to declare that Section 34B and D of the Immigration Act unconstitutional. And they were successful in that. The court said, I declare that these two sections are declared unconstitutional. But as you know, the courts might say that, and they say, we'll give you an interim order, but Parliament has been given an opportunity to amend legislation. So courts don't amend legislation, that's only the purview of Parliament. In this case, there was no amendment of the Immigration Act. And so 2 years had then passed. The present action then led to the present minister approaching the court once again and saying, not that he couldn't amend it, but he asked for basically another extension. Now, the judges were saying, no, your explanation does not carry much weight. The explanation went on 3 fronts. The process of COVID, the parliamentary fire, and there was one other excuse. And you could see from the judgment where the minister was now settled with a personal cost order of 10% of the bill. That was quite serious in the eyes of the judges. So I think the message that was being sent out was tardiness and ill preparation, and not doing what's expected to be done will not be tolerated by the courts. But that is only one part of the overall, let's say, amendment or reform of immigration legislation that has to be looked at.
Well, let me ask you the situation right now. I see that the other excuse was the 2019 elections. So the court's saying, don't come and say you can't do your job just because there's elections or a pandemic, and several years had passed, 6 years in total. So if you are a suspected illegal immigrant in South Africa right now, can you be held then indefinitely? I mean, we heard from a minister today that there's a problem with resources to repatriate individuals. Can you even be repatriated without appearing before the courts, or what is the process that is in place?
So let's clear up the first hurdle that was faced by immigrants that were detained. They did not have the right to appear within 48 hours before a judge or a magistrate or judicial officer. That has now been removed by the court order. And that is what the courts were saying, that Parliament has to now, in fact, amend so that it can reflect the law correctly. And the law is one of equality. It applies to all persons, citizens and non-citizens alike. As long as you're within the boundaries of the Republic, you are a beneficiary of the provisions of the Bill of Rights and the Constitution. So you can see there was a constitutional imperative being addressed there. In answer to your question, no, you cannot be held indefinitely. Like you cannot be held indefinitely without bail in a criminal case, you'll be entitled to your first appearance in 48 hours, and then the law takes its course from there. Bail is one of the factors or one of the means that you can obtain or you can try to obtain your freedom. Remember, bail is only pending the final case, and a number of factors are taken into account. So, in the event that an immigrant or even an ordinary person is unable to satisfy the judicial officer that he's going to possibly stand trial and not interfere with the witnesses and not be troublesome during the investigation, he probably will get bail. One of the factors for bail is either a permanent place of employment or residence, and you're going to have to prove your residence. And you can imagine that might not be very easy for many people. For example, we saw a number of people that had been housed in an illegal building or had taken residence in a building that was not fit for human occupation. And can you imagine now the department or the investigating officer has to go and confirm an address, because you have to satisfy the court that you have a fixed address and that you will ultimately reappear. So you could just imagine the kind of difficulties that people face when trying to apply for bail. But ultimately, bail is an option, or if the matter comes up for trial or a hearing, and in this case it'll be to determine whether you're in fact an illegal foreigner, and then a decision is taken. Now, an illegal foreigner, in terms of an NPA directive, has to be deported. That's one of the non-negotiables that is appearing right now. So there are other factors to be taken into account. Let's say you're a refugee and you didn't have an opportunity to get your papers sorted out or get your permit reinstated. Well, you'd become a candidate for such an action unless you're able to show that, look, I did go and I did try and do my application online. It was frustrated by the inability of the department to perform or send me an invitation. On the other hand, in terms of the Immigrations Act, there's something like 70,000 backlogged applications. So those people are potentially illegal as well because they don't have a permit to remain in the country.
Okay.
Yes.
All right. I'm sorry to cut you off there, but I hope we can chat further, because now this is a situation that Parliament has to deal with. No more delays tolerable. And of course, it links to what is happening with illegal immigrants. A minister saying earlier that resources were needed for that repatriation as well. That was immigration law expert Ashraf Essop.